Silence, court rise. Appeal in the matter of Nuneaton and Bedworth Borough Council and Hockley and another.
May it please the court, Brown for the Secretary of State, and then
Yes.
Meacher for the local authority, Mr. Royston for Ms. Hockley.
Yes.
My Lord, subject to the court's approval, we're proposing the following timings. I will speak first, and I estimate that my submissions will take about an hour, possibly an hour and 15 minutes. We've agreed that Ms. Meacher will then go next and speak for 30 minutes. And then Mr. Royston will speak in response to both of our submissions thereafter. He estimates that his submissions will take about an hour and a half, so that will take us over a short adjournment. And then I will reply this afternoon, and Ms. Meacher is content not to reply.
Yes. Well, if you can manage that timetable, that would be fine.
My Lords, I'm proposing to address the case as follows. First of all, I'm going to set out the facts and issue before the court.
Is Miss Hockley in court?
My Lord, she is.
Yes. Yes. Well, Miss Hockley, welcome. You have the misfortune of being in a very important case, unfortunately. You may feel you've won twice already, and yet here you are still having your case determined. But it is an important case, and in one sense, I am sorry that you're the victim of having to come all this way to get the point determined. Nice to see you. Yes, Mr. Brown.
My Lord, I'm proposing to deal first of all with the facts and the issue before the court. Secondly, with the statute and my submissions on interpretation. And thirdly, very briefly, I'm going to touch on some of the points that my learned friend makes in response.
Yes.
I'll return to those and reply. My Lord, dealing then with the facts and issue before the court. The court will have seen that this is a bedroom criteria or a bedroom tax appeal. The measure, as the court will know, has been politically and legally controversial in terms of its aims and effects. However, the measure and the percentage reduction are lawful. See the authority of Carmichael, to which I will return in due course. The court will appreciate that the measure seeks to deliver certain social policy and economic policy outcomes, which were canvassed in detail in the Carmichael litigation. But this case turns upon a pure point of statutory interpretation. It will be convenient, therefore, for the court to have the statute to hand.
Yes.
So you have that. It's behind the authorities bundle, tab 1.
Yes.
My Lord, the relevant legislation is the Housing Benefit Regulations 2006. Before I take the court through the regulations, if I may start with an observation. These are regulations about the calculation of a cash welfare benefit, i.e. housing benefit. They are not concerned with social entitlement to actual physical housing, still less actual physical bedrooms. So the structure of the regulations, as I will take the court to in a moment, is about establishing a methodology for allocating cash social entitlement. So a claimant presenting a claim for housing benefit claims cash. They do not claim a bedroom or entitlement to any particular form of housing. That's my first observation. My second observation is this. The methodology is based upon the concept of a bedroom as a proxy for need.
Say again?
The legislation is based upon the concept of a bedroom
Yes.
as a proxy for need. And this is a significant point when it comes to understanding the error of the upper tribunal and interpretation of the provisions generally. So what I mean by that is...
Mr. Brown, I think you need to slow down slightly.
I'm saying something.
Not at all.
So,
I haven't really quite followed.
let me
Concept of a bedroom?
It is a proxy for need. So the legislation uses the concept of size criteria and bedroom criteria as a way of quantifying cash entitlement.
Yes.
So a claimant doesn't claim a bedroom. A claimant claims housing benefit, but the structure of the legislation is to work out entitlement using a bedroom as a proxy for need.
Yeah.
Because like all benefits, it's intended to deliver cash towards need, but it's not need at large, it's a statutory construct which is intended to identify what the particular amount of assistance is that the state will provide to help meet need. So a bedroom is not a precise proxy, and this is not a tailored regime. It is a rough regime with a rough proxy. I'll develop this point in due course, but what we accept and recognise that a bedroom is an imprecise way of measuring need, but it serves a purpose here. And the reason for that is that, of course, every person needs a bedroom, and every house contains bedrooms. So as a way of measuring the amount of cash entitlement, a bedroom is useful. It's useful as a yardstick. There are different provisions within the regime which help pick up mismatches in terms of actual need and the need which is established by the size criteria and the regulations. They are principally in the form of what are known as discretionary housing payments, which the Hockley family has received, and those are payments which are made by local authorities in cases where there is a mismatch between the outcome under the size criteria and the housing benefit regulations and what an actual family might need because of other circumstances.
But am I correct in this, that the discretionary housing benefit has been made to the Hockley family because of this appeal?
That's right, my lady. So here they have it because of this appeal, but there's no challenge to the arrangements in general terms, whereby discretionary housing payments are available in principle to pick up a mismatch between deemed need under the regulations and actual need as might present in an individual case. That was the debate in the Carmichael MA litigation, whether that was a satisfactory structure, and the Supreme Court has held that it is.
It's a discriminatory structure. The Supreme Court held that it was not.
The Supreme Court held that overall, subject to two specific cases which have been dealt with in regulation, the differential treatment was justifiable, in particular by reference to the discretionary housing payment scheme.
Yes.
So the measure as a whole is lawful.
The discretionary payment scheme, is that a written scheme? Is that a policy or?
Yes, it's established by statute because it's a payment scheme, so it has to be statutory authority for the payments to be made. The statutory scheme then establishes the principle. There's guidance which is published by the Secretary of State to local authorities, but the local authorities are responsible for their own budgets and their own allocations. So an individual claimant presents a claim to a local authority for payment, and then that is determined by a local authority.
Under the guidance?
Under the guidance and under their own internal policies that they may have. As was canvassed in the Carmichael litigation, that is part of what the government described as its localism agenda, which is allowing local authorities to decide how best to allocate local resources. My Lord, that's discretionary housing payments. Another important part of this scheme are the social policy objectives, which I will come on to in more detail shortly. In broad terms, this is an instrument of social policy. The government is of the view that it is appropriate to use social entitlement in order to promote other outcomes. They include things like incentivising work. In particular, and I will show you evidence and authority on this, it is about ensuring that social housing is used in the most efficient way possible. So part of the government's social policy concern here, and I emphasise it's only part of it, was a concern that social housing is being paid for by the state in a way that is inefficient because there are people who are under-occupying, and that refers to people who effectively have more bedrooms than Parliament considers is appropriate.
We will have to justify all that.
Yes.
It's all very well for Council, for the Secretary of State to get up and say
Yes.
that this is the policy, but what his view of the policy is not necessarily the same as Parliament's.
Indeed, my lord, and I've got to make all of this good. This is simply by way of prefatory remarks at the moment, but
Yeah.
I recognise that. The flip side of under-occupation.
I'm sorry, just before we move on, you say that people are under-occupying because they have more bedrooms than Parliament considers appropriate. So that's sort of, as it were, the spare bedroom point.
Yes.
But isn't on matters slightly more sophisticated than that, because it's really to do with usage of the property. And of course, if you have a spare bedroom in that sense, that would be under usage. But as I understand it, it would be under usage if a property were used for a couple and two children under 10, as opposed to a couple and two older children.
Yes,
That could, in certain circumstances, be under usage, although the number of bedrooms in the actual house may be the same. Does
Yes.
that make sense?
It does, my lord.
It's not purely a number of bedrooms issue.
No, it's not purely a number of bedrooms issue because the scheme is about effectively a deemed usage of bedrooms. So the legislation, I'll come on to make this point in a moment, doesn't say anything about particular facts and circumstances of individual families. It sets out a broad criteria for what a family presenting with a couple, children, etc., would be entitled to.
And that really goes back to your proxy point.
Yes.
Really, it's a
Exactly.
it's a proxy, not an exact science.
Exactly the same, my lord. And this case is a very vivid illustration of what happened with the property, because the Hockley family quite understandably say, well, we use this property in a way that's perfectly understandable to ordinary people when one has regard to individual bedrooms. And we don't quarrel with that as an assertion, but that doesn't give effect to what the legislation is intended to do here. This is not legislation which is designed to accommodate the Hockley family. This is legislation which is designed to set up a deemed need entitlement under the bedroom criteria, apply then the reduction, which we'll see in a moment, the bedroom tax percentage reduction, and then that's the outcome, subject then to other mitigations in the system, such as discretionary housing payments. Before I move on to the detail of this legislation, the point I wanted to make about the flip side of the coin in terms of under-occupation is the problem of overcrowding. So the government is concerned about bedrooms that are spare, whether they are in fact truly spare or not on individual cases is not the point here, but the spare bedrooms. And there are also families who are overcrowding, so people who have insufficient bedrooms to meet what Parliament considers to be their needs. So, for example, a couple with 3 children who only have a 2-bedroom property. They are not in accommodation which is suitable for their needs because on application of the bedroom criteria, their entitlement would be at least a 3-bedroom property, and they are actually only in occupation of a 2-bedroom property. As I will show you in due course, the evidence which we served below for the tribunal was to the effect that there are 250,000 families who are currently overcrowding. And what this legislation seeks to do is to regularise or to improve the mismatch that currently exists. So reduce the number of families that are overcrowding such that they are then in appropriately sized accommodation. Now all of these points all work together because the court will have seen that there's another issue in play, that is saving public expenditure. If it were the case that all of the 250,000 families were housed in appropriate accommodation and there were no longer any spare bedrooms in the country, then no public money would be saved. So none of these factors runs on its own. They all run in tandem with each other. So So it's intended to deliver a broad range of social policy objectives, and I recognise my Lord's point that I need to make that clear. What I'm proposing to do now, though, is to turn to the wording of the legislation. So, my Lord, we start with Regulation 11. The Court, I'm sure, has some familiarity with social security legislation. It is drafted in a particular fashion. It is dense. I don't need to take the Court through all of it. I'm proposing just to say what the regulations are and then focus in particular on Regulation B13. So we start off with Regulation 11. The purpose of that is to establish entitlement on the part of an eligible claimant to assistance with rent. So it says eligible housing costs. For my purposes, I'm simply referring to that as being rent. It includes other housing costs, but I don't need to say anything more about that at the moment. The state provides assistance for housing costs. Regulation 12 over the page concerns the definition of rent. And again, I don't need to say anything about what rent includes for these purposes. One then turns to Regulation 12B, eligible rent. So the entitlement is not to assistance for everything that is within the definition of rent. There are certain eligibility requirements. They are not material for these purposes, although Regulation 12B is referred to in Regulation B13, so it's worth citing for that purpose. One then has very detailed and prescriptive provisions about what is eligible for assistance in Regulations 12BA through to Regulation 12M. I'm not proposing to say anything more about Regulation 12. The upper tribunal didn't refer to it and it's not material for our purposes. So if I can ask the Court then please to turn to A13. So when a maximum rent social sector is to be determined, so that's the circumstances in which there is to be effectively a cap on rent. So the assistance is not unlimited, there are restrictions in place. But it is B13 which is the material provision on which I'm going to make some submissions on now. So does the Court have Regulation B13? This is headed the determination of a maximum rent social sector. So again, my point about this being about calculating rent as opposed to allocating properties. One immediately sees the references to bedrooms, so see B13(2)B, and I'm going to go through this in detail. But there is no definition of a bedroom in the legislation. There is separate authority about what is properly described as a bedroom. I've brought along copies if the Court is interested, but it's not material to this appeal. The point there being box rooms, for example, are they properly described as bedrooms if they lack ventilation or you cannot fit a bedside cabinet in and things like that? And there's now established authority about what one needs to have in order for a room to be a bedroom. Here, subject to the remission point, these are all bedrooms, and that's the basis on which the appeal is proceeding. There is no concept in the legislation of a double bedroom. That's an important point when one looks at the way that the upper tribunal has reasoned this. There is only one single concept of a bedroom, despite the fact that some of the categories in paragraph 5, as we'll see in a moment, comprise two people and not one person. There's nothing about quality characteristics, nothing about sloping roofs, bunk beds, things like that. There is nothing about special cases in the legislation. So just by way of an example, if a person within the property has a particular need, for example, a need for a large room to accommodate medical equipment, that is not something that is provided for within the scheme of this legislation. So there is nothing that directs the decision maker to look at the facts of specific cases. Now, with those observations, if we can take the court through the legislation in a bit more detail. So it begins with B13 paragraph 1. The maximum rent, social sector, is determined in accordance with paragraphs 2 to 4. So that's the formula. So paragraph 2 is effectively the central part of the formula. The relevant authority must determine a limited rent by A, determining the amount of the claimant's eligible rent would be in accordance with Regulation 12B2 without applying Regulation 12B4 and 6. That's the reference back to Regulation 12B, which I mentioned a moment ago. It's not material for the purpose of this appeal. B is the critical provision here, as read with 5. But B provides as follows: where the number of bedrooms in the dwelling exceeds the number of bedrooms to which the claimant is entitled, in accordance with paragraph 5 to 7, reducing that amount by the appropriate percentage set out in paragraph 3. So that's the critical provision. It's the interaction with paragraph 5 of B13. And we say that that is essentially a simple mathematical calculation. One looks at the number of bedrooms in the dwelling, and one looks at the number of bedrooms that the family are entitled to under the size criteria, paragraph 5. If the first exceeds the second, then the appropriate percentage reduction is applied. And one sees the percentage reduction in paragraph 3. So 14% where the number of bedrooms in the dwelling exceeds by 1, the number of bedrooms to which the claimant is entitled, and 25% where the number of bedrooms in the dwelling exceeds by 2 or more, the number of bedrooms to which the claimant is entitled. Paragraph 4 provides for certain reductions in cases of excessive rent, not relevant here. Paragraph 5 is the bedroom or the size criteria. This is, along with paragraph 2, the material paragraph for the appeal. So that provides as follows: the claimant is entitled to...
Brown, before
Yes.
you go there,
Yes.
throughout the documents one finds the phrase size criteria.
Yes.
Is that a defined phrase? And
No.
if so, where is it?
No, so size criteria is a shorthand reference to paragraph 5.
Right.
The provision that I'm about to address the court on is known as the size criteria. With paragraph 5, the claimant is entitled to 1 bedroom for each of the following categories of person whom the relevant authority is satisfied occupies the claimant's dwelling as their home, and the words in parenthesis are important, and each person shall come within the first category only which is applicable. Then it lists out the various categories. So ZA, a member of a couple who cannot share a bedroom; ZB, a member of a couple who can share a bedroom. Those, as the court will see, are amendments to the legislation, and they were introduced following the Carmichael litigation. So A, a couple; B, a person who is not a child; BA, a child who cannot share a bedroom; C, 2 children of the same sex; D, 2 children who are less than 10 years old; E, a child. And one sees also that BA is a legislative amendment as well, which also follows on from litigation.
Probably doesn't matter, but the upper tribunal here has quoted the regulation in a slightly different form, missing out ZA and ZB, but including BA.
Yes.
Is there any reason for that?
No. No, the tribunal, I think, is actually right in that respect. So BA came first, and ZA and ZB came after. So BA followed on from an earlier case, Burnett. ZA and ZB followed on from Carmichael, and were, to the best of my recollection, introduced in the period since the upper tribunal's judgment. So the tribunal is right in the way that it set out the legislation at the time, but we were before it.
And so we ought to set it out in the same way as the upper tribunal has.
Yes, my lord, yes. court will appreciate that nothing turns on either of the two sets of amendments, the ZA or the BA.
No.
This is the first time I've seen ZA and ZB. I understand ZA, which is Carmichael. ZB, can you just explain that? A member of a couple who can share a bedroom?
Yes, so if one takes the example, say, of the Carmichaels, and this is in the authority, so one of the couple can share and one of them cannot share. So in that situation, Mrs. Carmichael cannot share, so she is entitled to a bedroom under ZA.
Yes.
Mr. Carmichael is a member of a couple, and he could share himself, but he doesn't have a home unless one implements ZB as well, because he's not a couple himself. I suppose one could say he's a person who is not a child.
Why? But doesn't ZB cover two people, each of whom could share a bedroom?
No, because it's a member of a couple who. I see my lord's point. So theoretically, if one has a couple and they both fall within the first subcategory, then why don't they go to ZB and not A?
Well, why don't they go into ZB and not A?
Yes.
Sorry, yes, sorry, yes, exactly what you said.
Perfectly fair point.
Anyway, but so you understand the point, but it's not relevant in this
No,
case.
it is not, but thank you. I certainly see that point.
Another reason for the judgment in this case not quoting the.
Yes, very good reason.
So somebody's going to have to go back to think about that.
Yeah.
For our purposes, though, sorry, before I just deal with our family unit, please note there's not a category of a single child under 10. So the upper tribunal made a minor error in thinking that there was such a thing here in the size criteria as a child under 10 in terms of a single child entitlement, but there isn't. So if the family unit comprises a child, it doesn't matter if it's a 15-year-old child or a newborn baby for these purposes. That may or may not have some significance, but I'm simply pointing it out that that's a minor error in the upper tribunal's decision. So turning to the family unit here, the Hockley family unit. So that comprises a couple, so B13(5)A. So that is the first applicable category, just leaving my Lord Justice Hickinbottom's point to one side. And the entitlement is to one bedroom for the couple. And it also comprises two children of the same sex. And the first applicable category is category C. So it is one bedroom for the children. So the prima facie entitlement under B13(5) is two bedrooms. And everybody agrees on that.
That applies until the two children of the same sex, one of them becomes an adult.
Yes. So when one of them becomes an adult at the age of 16, then there's a reassessment.
16 is the age, is it?
Yes.
When you become an adult these days?
For purposes of this legislation, my understanding is 16.
Yes, right.
The home, the Hockley family home in Wisteria Way, comprises 3 bedrooms. At least one, but 2 are small, but they are bedrooms.
You accept, I think, that neither of those 2 small bedrooms is suitable for 2 children.
Yeah, for the purposes of this argument, I'm prepared to accept that neither is suitable for 2 children. That's effectively the point we need resolving on this appeal.
Yeah.
So the issue then is fairly straightforward when one looks at B13(2)B in terms of the calculation. We say that there are 2 stages. The first stage is you just identify the number of bedrooms in the dwelling, and here it is accepted that objectively the number of dwellings in the number of bedrooms in the dwelling is 3. So that's the number of actual bedrooms, and you input that into the equation at the first stage. And then the second stage is to look at the bedrooms pursuant to the size criteria on its proper interpretation. This is the point that the court has to resolve. So on that, the local authority and the Secretary of State say that the outcome of the size criteria, as I've taken the court through a moment ago, must be 2 bedrooms for the Hockley family unit. Whereas Hockley says statutory entitlement is 3 bedrooms because of the configuration of the bedrooms at Wisteria Way.
When you say configuration, you mean size?
Yes.
And the difference between you, I mean, it seems to me that this is the issue.
Yes.
You say that subparagraph 5 is actually a hypothetical construct, or at least an objective criteria.
Yes.
It's objective.
Yes.
Whereas the respondent says it's actually subjective, and that's the issue.
Yes, that's a perfectly fair way of putting it, my lord. Yes. They say subjective in that one has to look at 2 things, really. One has to look at either the individuals or the inherent characteristics of the class. And that's how the tribunal has put it. But they say that if one's looking subjectively, you're either looking at the actual people or you're looking at the inevitable characteristics of the class. Not clear what that means, other than the fact that some of the classes comprise 2 people, and therefore that seems to mean that if you're within the class that comprises 2 people, you need to have a double bedroom, effectively. So it's bringing in a concept of a double bedroom. If it's subjective, and this is a point I made before, then there is really no end as to what one could look at. So take the example of somebody who needs a room for storage of their medical equipment. Assume that is established as a fact. Why is that person in any different position? Why is that person not entitled also to a double bedroom? Because his or her need for the additional space is the same. But the legislation doesn't say anything about that. There's nothing about that subjective inquiry into individual facts at all.
And that again really goes back to your proxy point.
Yeah.
That this is no more, it's no less, but it's no more than a proxy.
It's no more than a proxy.
For need. It's not actual need.
Yes.
It's simply a proxy for need.
Indeed. Need being picked up elsewhere in the system. So, in a sense, that really does bring me to the crux of my submission, and I'll make it. I think the report has it, but we say that you simply look at entitlement under paragraph 2, irrespective of the knowledge, any knowledge the decision maker has of the characteristics of either the family unit or the property. There are 2 components to the statutory construction point that I'm making. The first is that simply follows from the language. That's simply application of what the statute says, but it's also confirmed by an informed understanding of what this legislation is intended to do. So, fundamental principle of statutory construction, the tribunal should approach the statute as an informed tribunal. It's not, we say, for us to evidence things that we say are proper to an informed tribunal when carrying out its task of interpreting a statute. We have evidenced it, but in any event, we say that there's no evidential burden when it comes to statutory construction, and that the tribunal should be assumed, the tribunal should assume for itself an understanding of some of the social purpose of this legislation, which appears from its face as well. So, for example, the fact that this is intended only to be a method of calculating rent, as it says on its face, is important. That point should have directed the tribunal towards what I'm describing as the proxy argument, as opposed to something else, i.e. looking at whether people have got appropriate housing. It's not about appropriate housing. So the tribunal respectfully erred in those respects, but what I'm proposing to do is very briefly make some observations about why we say the language supports our submission. Then I'll deal with points about social policy, in response to my lord, and then that's effectively my case on interpretation. So just dealing with the language, we say that our approach follows the language of paragraph 5. So the language is, the claimant is entitled to 1 bedroom for each of the following categories of person. So the word is entitled to 1 bedroom, but again, that is entitled to 1 bedroom for the purpose of quantifying state assistance, not entitled to one bedroom in any other respect. And the entitlement is to a bedroom for each of the following categories, and that's important. So the word categories is indicating to the reader that this is entitlement by reference to broad categories, not individuals within those categories. So the categories themselves are depersonalised. Except for the specific provisions that apply by pursuant to the amendments, one knows nothing about the individual characteristics of the people within the category. So two 15-year-old boys are treated the same as two newborn boys, even though they obviously have very different accommodation needs. Now, when one looks at the decision, the upper tribunal seems to have accepted that. Critically, our approach gives effect to the words, each person shall come within the first category only which is applicable. So we say that is mandatory language. There is no proviso or no exception if a bedroom is not qualitatively sufficient for that category. Simply not there. So it is not open to a decision maker or a tribunal to say that two children of the same sex, first category, i.e. paragraph C, can be taken out of that category and placed into a lower category, i.e. category E, as the upper tribunal has done here, because of concerns about the quality of the bedroom that they occupy. The legislation does not say that is something the decision maker is entitled to do. You can't disregard that language. You can't take individuals out of the first category into which they fall and put them in a lower one. So the analysis is the same, irrespective of the number of bedrooms in the property. So 1 bedroom, 2 bedroom, 3 bedrooms or 4 bedrooms, it makes no difference in terms of the size criteria. We say that the word for, which the upper tribunal has placed significant emphasis on, is consistent with the interpretation which I have outlined, because the entitlement is to 2 bedrooms for the purpose of calculating rent. So it's not 2 bedrooms for the purpose of accommodation. It's 2 bedrooms for the purpose of calculating entitlement. That's what the word for means, read in its proper statutory context. So with respect to the tribunal, there is nothing which supports an interpretation which allows you to adopt a different approach, notwithstanding the desire to accommodate the facts of the case, the particular circumstances of the family that presented before it. So that's all I wanted to say about the language. Turning then to social context, we say that our interpretation furthers what the tribunal should have recognised to be the social context, the social policy objectives which I outlined at the beginning of my submissions. And we say that the tribunal should have appreciated it without looking at anything else. It should have understood that this legislation, in the context of a housing benefit scheme, is about a methodology for calculating entitlement and nothing else. In any event, the social policy in question does have a degree of notoriety. Other tribunals which have considered this, and I'll take you to the 2 Scottish decisions on the point, they both immediately recognised the concern about inappropriate use of social housing being one of the factors that drove this legislation. They weren't shown any materials, but they knew it. And they knew it because they were specialised tribunals operating in this sector. And this
Would we not primarily take what the social policy is from what the Supreme Court said in Carmichael?
Yes. So my next point was going to be, there were 2 sources before this tribunal anyway. The first is Carmichael, and the second is the witness statement. So can I show you Carmichael, which the tribunal had and made some reference to? So That's behind tab 8 of your authorities bundle.
But your primary submission is that these provisions, as are other benefits provisions in respect of different benefits, does not attempt to tease out actual need.
Correct.
It simply sets out criteria, actual need for space.
Yes.
In this case.
Precisely.
It's actually a proxy for the space, not simply bedrooms as a proxy. It identifies criteria, proxy criteria, which then equate to cash benefit.
Indeed. And they equate to the amount of appropriate assistance by way of cash benefit.
Yes.
When one considers it with the percentage reduction as well, then the view is, well, this is what you get by reference to deemed need, but if you have too much, and therefore the state should reduce its assistance, and you should then consider what to do about that yourself. So the answer to my last question is yes, it is simply a proxy though for establishing what amount of assistance should be provided to help with need. So not even to meet need, because there's no obligation on the state to meet need. The obligation is only to provide entitlement in a way that Parliament decides is appropriate.
Yes, thank you.
But now, supposing Mr. Royston persuades us that on the true construction of the regulation, it does in fact require the court to look at the need, or however you use the word for, or whatever. Are you saying that these considerations should override that natural construction?
No, my point is natural construction is as I set out.
Of course.
It's reinforced by the social policy points that I'm addressing the court on now. If the court's with Mr. Royston and we've not drafted it effectively, then we recognise that and we'll have to go and do it again. So primarily, fundamentally, this is a statutory
So
interpretation.
this is very much a subsidiary part of the argument.
Yes, it is, but it is a principle of statutory interpretation that one considers the mischief, the social context of the legislation, and the reason I'm taking this court to it and the reason we took the court below to it is because it reinforces what we say should have been apparent from the face.
If we actually thought it was ambiguous or we couldn't understand what it meant, then it would be a highly relevant consideration.
Yes, it's not irrelevant even if it's clear, because it really reinforces my point.
Yes.
It can give the court some comfort that the interpretation that we're advocating is correct. It may be belt and braces, but it's helpful because context is always helpful when construing any legislation. My Lord, Carmichael, now it's dealt with in a fairly summary fashion, but that's because it's sufficiently clear. So it's paragraph 16 of Lord Toulson's judgment, who 4 other members agreed. And the judge makes reference to a very detailed exposition by Lord Justice Laws in the Divisional Court, which is reproduced at Appendix 2, and says this at the 5th line, in summary, as part of its policy for curbing public expenditure, the government aimed to ensure that social sector tenants of working age who were occupying premises with more bedrooms than they required should, wherever possible, move into smaller accommodation. There was a lot of underlying evidence in support of all of that.
Just pausing there, what Lord Toulson seems to be saying is the policy is curbing public expenditure.
Yes, so as part of its policy, there's no doubt that reducing expenditure is part of this, but as part of that, there is a secondary social objective, which is to ensure more efficient use of social housing. So
He doesn't exactly say that, does he? What he says is the policy is curbing public expenditure, and the way you do that is to ensure that people who have more bedrooms than they require should move into smaller accommodation.
well, that wouldn't in fact...
He's not saying that's the policy.
Yes.
He says the policy is saving public expenditure.
Yes, so there is no doubt that the starting point for all of this was part of deficit reduction, etc., and that this was considered to be a way of reducing expenditure, it has to be.
That
considered-
tells us nothing about how to construe the legislation.
Exactly, but then a decision is made as to whether this is an appropriate way of reducing expenditure as against all of the other candidates that there may be. And the reason why this is identified as being an appropriate way forward is because it delivers other social policy goals too. For our purposes, that includes more efficient use of social housing. But as I mentioned before, if that second policy is in tension with the first, because as soon as somebody goes into an appropriate property, then the reduction does not apply to them, and therefore the cost saving which arises from the percentage reduction disappears. So there is a tension. But Lord Toulson is clearly right when he says that this is part of a policy which effectively commences with reduction of spending, but then looks to deliver other social policy goals along the way. And that's what all of the evidence before.
It's a way of delivering the main public policy.
Yes.
I suppose you can call it a sort of sub-policy, if you like. The way we're going to deliver our aim of having less expenditure is to make people leave houses who have too many bedrooms.
Well, but respectfully, my lord, that second sub-policy is in conflict with the first. So it can't be the case that more efficient use of social housing is itself designed to reduce expenditure, because more efficient use of social housing means that nobody's subject to the percentage reduction.
My point is that the driving force,
Yes.
according to Lord Toulson,
Yes.
is, I don't know what he derives it from, but the driving force is saving public money.
Yeah, the driving force is undoubtedly saving public money. That is clear from the context, the origin of the scheme, the timing of the scheme.
And as I say, that tells us nothing about the meaning of the legislation.
Saving money tells you nothing at all about it. It's about the other social policy goals, which are recognised by the Supreme Court as part of it. But this is macro policy, so clearly there is a very compelling economic case for reducing expenditure. That's the view of government. But one can't ignore the social policy goals that a policy designed in this way are intended to further as well. There's all sorts of ways of reducing expenditure. It didn't have to be a percentage reduction by reference to spare bedrooms. It could have just been a flat rate reduction of housing benefit, generally. But the reason why it's done in this way is because this way achieves a social policy goal which is fundamental. So it may be the court properly describes it as being a sub-policy, but it's a sub-policy to a very large other policy. So on its own merit, it has considerable substance.
I think we have to be very careful when we talk about public policy, because there are levels of public policy, and Lord Toulson was looking at one particular level.
Yes.
But I mean, it seems to me that perhaps the overarching public policy had nothing to do with bedrooms. It was to ensure that those who lived in social housing were not in bigger, in inverted commas, premises than Parliament considered appropriate. That's step one. Step two is that the number of bedrooms, for the reasons you've given, was a proxy for the size of the property, the appropriateness of the property. Bedrooms is only a proxy.
Yes.
So when Lord Toulson says that it was government policy to make sure that individuals were not occupying premises with more bedrooms than they required, he was actually there, it seems to me, looking at a proxy, not the overarching policy.
Yes.
And the third stage in this is that when he says that it's the policy for curbing public expenditure, it seems to me he wasn't necessarily considering absolute expenditure. What he was considering is saving public expenditure on saving public money on inappropriate expenditure. That is expenditure on families living in bigger, in inverted commas, premises than Parliament considers appropriate. So I think you have to be careful at looking at this passage about public policy too forensically.
Yes.
In looking at it as though it were a statute.
I think that's obviously right, my lord. I do agree with that entirely. It's an efficiency point, ultimately. And again, this is something we say the tribunal should have recognised. When one is looking at social entitlement, it is inevitable that the government is looking to spend money efficiently under any statutory scheme. And this here is designed to deal with inefficiencies within the system. As my lord puts it, a bedroom is, there's no fundamental intrinsic value in a bedroom itself. It simply is a proxy for size of property or suitability of a property. There will be very large single bedroom properties, very small 3-bedroom properties. That's not the point here, but it is a way of targeting resources in a way that is more efficient. And that's Lord Toulston is developing on that, my respectful submission, because that fundamental point about the efficiency of state spending should have just been clear and obvious throughout these proceedings, and was no doubt obvious within this Carmichael litigation as well. The government doesn't want to waste money. It's identified this as being effectively a poor usage of money. Not in every case, for the Hockleys, possibly not, but in general terms, that is what the policy objective is here.
Do you also go this far to say that in terms of, not perhaps all benefits, but most benefits, the use of proxies to a certain extent is inevitable, because you have to convert need, which is very much an idiosyncratic, case-specific matter. You've got to convert the need of lots and lots of people into ultimately a cash benefit.
Yes.
And therefore, as I say, not perhaps in all benefits, but in lots of benefits, you have to have a proxy for immobility, or you have to have a proxy for lots of needs to be able to convert it into a cash sum.
Absolutely. It is inherent in, effectively, the whole scheme. So those proxies can be very detailed. One sees that in the disability legislation, and the particular statutory schemes are very detailed. But even they use proxies such as ability to cook, ability to dress, etc. They're not specific to a person, they're within categories, and that is intended to then transpose into cash, because cash is obviously of assistance if one has those sorts of deemed needs, but it's not tailored for anybody.
Because otherwise it seems to me that you'd have to have inspectors going around every person, claiming every benefit, to look at their specific circumstances, which may in any event be varied.
Well, exactly. So what if one has a very small bedroom and a very large person? Does one then take the view that that bedroom is not appropriate because there's somebody who is just very, very tall, they can't reasonably, in fact, accommodate that bedroom? Do we then change the entitlement? Does that bedroom cease to become a bedroom, or do they somehow become entitled to a so-called double bedroom? It can't be done, and that isn't the scheme anyway of any benefit legislation. So this simply reflects what happens elsewhere in the system. And the reason why it's perhaps considered to be controversial is because it uses for the first time a bedroom, and a bedroom is a particularly intrusive proxy in some respects, because it does at least envisage the state looking inside people's accommodation and seeing in fact what their bedroom needs are. And unsurprisingly, people consider that to be, to some extent, a matter of concern. So it's a particular proxy which has proved to be controversial, but there is no doubt that that's all it is here.
But proxies are inevitably sensitive in this area because proxies, as you've said, are rough.
Yes.
The proxies are necessarily rough, and in some cases, the application of the proxy will just not look quite right.
No,
I know there are mitigations elsewhere in the system, but proxies inevitably have that roughness.
but in the Carmichael litigation, it was stark, the fact that there was this mismatch. Take the example of Mrs. Carmichael, who, on any view, cannot share the single bedroom to which she is entitled. No dispute about that as a matter of evidence. The proxy completely fails. But the overall scheme of a proxy is not declared to be unlawful. Yes, in fact, there is a declaration in her case, and that results in an entitlement to another bedroom, but it's still just changing the proxy. It's not suggesting that the state needs to provide Mrs. Carmichael personally with something different. And if one looks at all of the cases that failed in that litigation, so all of the MA cases, which are people with severe disability-related needs, none of which present on the facts of this case, but very severe disability-related needs, which meant that they could not, in fact, use the room that they were entitled, or they had a demonstrable need for an additional room or a larger room. All of those claims failed, notwithstanding the fact that they presented with very compelling personal circumstances and arguments as to why the proxy failed for them. And it did. It failed. But the government's response was, that's not the end of the story here, because there are other mitigations in place which pick up the gap for those people. And it's no different here. In this argument, it's exactly the same. When my learned friend seeks to address you on discrimination, my response will be, that's all been determined by the Carmichael litigation. It's not open to him to say it's discriminatory now in those circumstances. Carmichael was the first point, and the second was Miss Walsh's witness statement, which is behind tab 12 of the supplementary bundle. Now, my lord has said, well, an officer of the DWP, what does she bring to the analysis? Well, it's there, it's evidence that we put before the tribunal because the tribunal asked us. So after the hearing closed, the tribunal said, can you please serve some evidence which explains what the social policy is? So that's why we did it. If I can invite the court to look at it, please. So it's page 219 of the supplementary bundle. The relevant paragraph, please, is paragraph 14 on page 225. And rather than my reading it out, if I ask the court to read, please, 14A through to the bottom of page 226.
Yes.
So, my lord, we rely on that insofar as it is necessary to do so, as confirming the social policy objective in question, which we say the tribunal's decision frustrates. I've not made any submissions on the decision itself. Perhaps if I can briefly do that. So the decision is at tab 8 of the bundle.
Where are we going now?
The upper tribunal's decision itself, which is behind tab 8 of the court.
Oh, yes.
So one sees at paragraph 2 the way that the tribunal defines the issue, and they call it the connection issue. And I don't quarrel with the way that it's defined, although I note that there's already tension in the way that the tribunal refers to, this is the fourth line, the reference to the particular individual or class of individual. Because those are two completely different things. One can have a particular individual, say a particular single child, say, who presents with certain needs, and then the class of individual. Now, what does a class of individual mean? It doesn't seem to mean anything other than the fact that it's either one person or two people, because otherwise, what could it be? the introductory remarks and the legislation, the tribunal paragraph 6 sets out how the issue arises on the facts. And the court would have seen there is some history in terms of this going back to the first tribunal on more than one occasion. The material part of the analysis is from paragraph 9. So if one looks at paragraph 9, what the tribunal says here on the 4th line is that when one is looking at the categories of person occupying the dwelling as their home, the tribunal says that depersonalises the assessment so that the characteristics of the actual individuals concerned are irrelevant. Now I agree with that, but it is difficult to see how that then follows through in the tribunal's reasoning, because they then effectively reach the opposite view, that the characteristics of the person or possibly the class must be determinative. But we say the tribunal was right in paragraph 9 and then failed to effectively apply that analysis. This is a depersonalised assessment. In paragraph 10, the argument for Secretary of State and local authorities that the next task is to identify the number of bedrooms in the dwelling without reference to the categories of persons who would have to occupy them. Now we have debates about hypotheticals, and ultimately I was asked the question, well, what if it's 3 small bedrooms? How many bedrooms do you say it is? And I said, well, the answer's in the question. If it's 3 small bedrooms in the property, then the answer is that property has 3 bedrooms. It doesn't have 0 bedrooms, just because they're small and because the family unit which was presented comprises double categories, as it were. So objectively speaking, the answer to the tribunal's question is, if there are 3 small bedrooms in a property, there are 3 small bedrooms in a property. Forgive me if I didn't make that very clear, but that was the point I made to the tribunal. The tribunal said, no, that is absurd. If you have got effectively double categories, i.e. categories comprising double people, a couple or 2 children, then those small bedrooms are not bedrooms. That was effectively the
You
tribunal.
appeared in front of the upper tribunal, did you?
I appeared before the tribunal, yes.
And so the Secretary of State was separately represented as he is here.
Exactly the same,
Yes.
all the same, yes. Anyway, difficult to see how the hypothesis can really drive the proper interpretation. The starting point should really have just been, what does the language say? Now, of course, sometimes hypotheses can be a way of checking and sense checking, but the tribunal here seems to have started off with what it thought was an absurd outcome, and then let that judgment dictate the rest of its analysis. So it was a curious approach to interpretation and seems to have resulted in error, in my respectful submission.
So when they attempted to take a point to destruction, as I think they put it, you're saying there was no need to go there. You simply look at the statute and construe it.
Yes.
That's it.
Exactly so, my lady. You look at the statute and construe it. If it does throw up some situations which are odd, that is just what Parliament intended, because that's what the language says.
And there are mitigations. There may be an issue how adequate they are, but there are mitigations elsewhere.
Yes, there is no issue in this litigation about adequacy of mitigation. Lincoln takes a point about taking in a lodger in his skeleton argument. I accept that that particular mitigation can't arise. But it may be that none of them can, and that was the case in the Carmichael litigation. So all of the government's mitigating or behavioural ideas for people, such as taking in lodgers, working, etc., they're all completely unsuitable for people in that litigation. And it may be that many of them are unsuitable for the Hockley family. I don't know, but it's not a case of, well, are those mitigations appropriate on the facts? It's about looking at the scheme in general terms. And in any event, the government has in place a DHP scheme, which picks up cases where other mitigations simply don't arise. But all of that is lawful. So, in answer to my lady's question, it should have just said, well, what does the language say, really? And if it had done that, then that would have been the beginning and really the end of the matter. So the hypothesis is at paragraph 11. Paragraph 12, it just says, well, it's absurd, without saying what the issue is on the language of the statute, which it considered to be absurd. The outcome of the hypothesis might be absurd, but that doesn't mean that the legislation doesn't mean what it says.
But absurd or not, depending on your starting point, as I understand it. Your starting point is that 3 small bedrooms are 3 bedrooms.
Yes.
That doesn't mean to say that any particular family can live there. It may be that no family can live there, but in any event, it doesn't mean that any particular family can live there. But if your starting point is you look at the particular family, then the result may be absurd.
Yes.
I mean, it seems to me to be almost a circular point.
Yes, maybe I'll be right, my lord. I'm not prepared to say anything more about it because it's difficult to see how it really furthers it one way or another. We say the starting point is simply the language, but if the court needs any further reassurance as to whether this is intended to be a property scheme or a fact-specific scheme, then it's all the points I've already made about overall social policy, what benefits legislation in general terms looks to achieve, and the absence of any reference to the case before the decision maker. Just nothing in legislation says look at your individual facts.
So is the consequence of the upper tribunal's decision then that you can't answer the question of how many bedrooms the property has unless you know the family that's occupying it, and if it's this family that's occupying it, there is effectively only 1 bedroom, whereas if there is a family with a boy and a girl, it is a 3-bedroom property.
Yes, there may be another way of interpreting their decision, which is, well, in fact, the bedroom it is 3 bedrooms, but the entitlement has somehow changed, and the reference to only falling within the first category which applies, that is implicitly tweaked when one looks at the plan of the house. That if one sees that there are 3 bedrooms, yes, you accept there are 3, but because they're all so small, then the 2 boys who are expected to share become entitled to 1 each. That's another way of interpreting the decision of the tribunal, but there's just no support for that in the legislation. There's nothing that allows you to disregard the first category and then to drop the 2 boys into the lower category. But I had understood at the oral hearing that it was the first way that my lord put it, namely that you've got this transient concept of a bedroom, and that if we have the plan before the court now, and we were all looking at it, we wouldn't be able to answer the question of how many bedrooms are in the property because we didn't know what the family unit was or what the next family unit might be, etc. But either way, it's wrong. It doesn't matter if one is unable to say how many bedrooms are in the property objectively. Of course, one must be able to do that. And it's equally objectionable for the tribunal to say that you can just disapply categories if you've got a small bedroom before you, because there's nothing in the legislation which allows that either. So the tribunal didn't deal with the fact that this property, the Wisteria Way property, could be accommodated by another family in a way which is efficient, i.e. properly uses all of the bedrooms, in the sense that if the family, instead of having 2 sons who are expected to share, comprised a son and a daughter above the age of 10, who the legislation treats as not being appropriate to share a bedroom, that family could occupy this property and all of the bedrooms would be used efficiently. The present occupants would therefore have to move into another property, which is in fact an ordinary 2-bedroom property. And my learned friend says, well, that's going to infringe their convention rights, that's not in their best interests. That argument, we say, is not open to them following Carmichael, but it's self-evidently wrong. There is nothing inherently objectionable about a family living in accommodation which is appropriate for their needs. That's the social policy of the legislation. It benefits the hypothetical other family who are currently overcrowding, and Miss Walsh tells us that there are 250,000 of those families. No one has suggested that the state has breached their rights, despite the fact that they are currently living in unsuitable accommodation. And it would be a bizarre outcome if legislation which is intended to improve this situation is treated as somehow being objectionable when it does precisely that. So tribunal just reasons its way through from 13 to 15, but having effectively, my lord put it, started off from a different starting point, its conclusion becomes inevitable, because it says, well, it's a small room, and therefore we are going to find that the entitlement has gone up from 2 to 3 under the size criteria.
Well, the real difficulty is that there's nothing in, let's call it, Regulation 5, which allows, on one reading, for the type of exercise this tribunal is proposing or suggesting.
Indeed, it's simply not permissible, and in its mandatory language it says the opposite, that you can only come within the first category when you go down the list. And when you're in that category, you can't come out of it under any circumstance at all. So the tribunal is striving for a solution, but it's not one that's legally open to it. And it is respectfully trying to find a solution for the family unit, the Hockley family unit, without regard to the wider picture, which is the perspective of the Secretary of State, which I've been making submissions on. And they deal with our point about social mobility at paragraph 18. And all they just say is, well, Ms. Walsh's evidence doesn't assist and Carmichael doesn't assist. But they don't say why. And
No, the essence of the reasoning is really in paragraph 12.
yeah, yes, the essence of reasoning is certainly paragraph 12 through to 15. So we say it's wrong. We also say that the other two cases which have considered this specific point are right. And it might be helpful if I just very briefly show you those and then I'll sit down. But there are two Scottish decisions. The first is
Just on these decisions, and I'm not sure this is going to be relevant for our purposes. In fact, I'm fairly confident it won't be. But the two cases are an upper tribunal decision which was physically in Scotland,
yes.
about Scotland,
yes,
where the tribunal comprised, I think, High Court judge from here,
it's just a Charles, yes.
an outer house judge from Scotland, and a senior upper tribunal judge from Scotland, Scottish QC. That was the upper tribunal case, and then that was relied upon, I think, in the Scottish inner house case. That's a Court of Appeal case, with obviously 3 Court of Appeal judges. Now this tribunal, I think, said that the Scottish case wasn't binding upon it.
Yes.
Now, the Scottish case is persuasive for us,
Yes.
really quite persuasive, because it's on exactly the same provision, but only persuasive.
Yes.
But in terms of the upper tribunal, wasn't it binding on the upper tribunal? Essentially, well, it wasn't binding on the upper tribunal. The upper tribunal is a single entity,
Yes.
which covers England, Wales and Scotland.
Well,
You may, I mean, you
This-
don't have to answer that question
Yes.
if the question is not going to be determinative of us, but it just struck me that it probably was binding upon them.
yes. I mean, they went as far as to say that even if it had been English Court of Appeal, they wouldn't have followed it. So they have
Yes,
a
it's
fairly
robust
view.
fairly robust view, yeah.
Yes. But I've obviously considered these points on precedent. Here we're in the Court of Appeal.
So it doesn't. So they don't matter to us. It's persuasive.
Well, you're not bound by the Court of Session. You would be bound by the Court of Appeal. But as things stand, you're not bound by any of this at all. So I was proposing to address the court on the basis that you can follow it or not. And that the reason why I'm taking you to it is that it is right, and therefore it...
I understand that, which is your
Yes.
primary proposition, but it's persuasive for us.
It's persuasive for you, but
Yes.
if the upper tribunal has failed to recognise the doctrine of precedent, which it may well have done, I'm not sure if that really makes any difference here,
Right.
because if they got the right decision,
They were either
but
right.
ignored precedent,
They were either right or
Yes.
not right.
ultimately, yes.
Yes. I think that's fair.
This court would then effectively just remake it, even though it was technically wrong for failing to follow the precedent obligation upon it.
Yes.
So
My Lord raises a very difficult point, really. It'd be very odd if a tribunal sitting in England were bound by a Scottish decision. if we were not. Because if you have a single jurisdiction, as the upper tribunal is, to have separate appellate jurisdictions makes a bit of a nonsense.
Well, it's a challenge because then after the Court of Appeal you go back to
Yes.
a unitary court, the Supreme Court.
Yes.
But I mean it's not unusual, certainly historically it's not been unusual for the upper tribunal to hear cases at the same time, because they raise the same point, from Scotland and England.
Yes.
And that would result, if this is right, in some mental gymnastics, I think.
Yes.
But anyway, we don't. I think it may be a difficult point, but it's not a difficult point that we have to grapple with.
No, I would respectfully agree. Because of where we are now, you have effectively a clean slate to decide in the way
The
that
point,
you
yes.
Whilst you're on it, the tribunal may have seen why it felt entitled to go the way it did, and paragraph 28 was quite a curious remark about the fact that the upper tribunal president directed them to hear it, which they thought gave some comfort that he implicitly thought his own judgment was wrong. I'm not proposing to make any submissions on any of that. As in, my position is that I'd invite the court simply just to decide what's the pure point. But IB and Nelson's, IB is behind tab 9. All I'm really proposing to show you are the paragraphs which we say are exactly the same as the submission that I'm advancing to this court. And IB.
It is a very different issue. I mean, there, the occupants have converted a bedroom into a second living room.
Yes, but so that's one of the reasons that the tribunal says, well, it's not quite on point, but they do deal with the specific point about, as it's described in both the Scottish cases, do you look at the property as if it were vacant?
Yes.
The material reasoning is 17 onward. So there, the tribunal did direct itself to Lord Toulson in Carmichael in terms of.
It's not a tribunal, this is the Court of Session.
Forgive me, my lord, yes. The Court of Session, it was able to discern the social policy from Carmichael. The specific point, it would be helpful if I could invite the court, as part of this deliberation, to read paragraph 17 through to 23. But the specific point is at paragraph 21, when the court session specifically deals with point of interpretation of the word bedroom and the issue about whether you focus on the property when vacant rather than how it's actually being used from time to time. So I recognise it's a configuration point as opposed to a structural starting point, that the bedrooms are just too small, but it's no different in terms of approach to the legislation.
The actual decision is effectively in paragraph 19, isn't it?
Yes. Yes. The reasoning goes through to 23. And if one looks at 23 in particular, so from the fourth line, for example, in a particular property, there may be a room available which is not big enough for a double bed, but the room is otherwise suitable as a bedroom to accommodate a child in a single bed. In our opinion, that room may still properly be classified as a bedroom, even although the particular occupants of the property have no child and the room is too small for the couple who live in the property and need a bedroom. So that, we say, is effectively on the courts. We consider what is required in assessing whether a room is a bedroom is an objective assessment of the property as vacant, which is not related to the residents of the property or what their actual use or needs might be. The use and needs present may vary from time to time, and the number of residents may also vary. This may lead to what might be regarded as overcrowding or under-occupation as defined by Regulation B13 at a particular time. None of that, however, affects the prior question, which in our opinion is determined objectively as the number of bedrooms in the property. So here, where it says that might result in overcrowding or under-occupation, it may also result in what the Hockley family would describe as appropriate accommodation legislation for them, but from the perspective of the Secretary of State, it is still treated as being under occupation. That is just the outcome of the legislation.
So you say the upper tribunal is not really consistent with the reasoning of this Court of Session case?
No. So unpersuasive reasons for not following it, both as a matter of precedent and in terms of what it actually decided, because the tribunal basically says, well, they're focusing more on configuration, whereas we're looking at qualitative bedrooms and double bedrooms, although it doesn't use the term, which I suppose there is some distinction there, but it's not compelling when one's looking at the overall statutory scheme. And we say that the Court of Session here properly directed itself to the correct social policy and simply just read the statutory words and therefore got it right. The other authority is Nelson, essentially the same, behind tab 5. So this is the Scottish Upper Tribunal. And it's at 19. This was Mr. Justice Charles and members, as my lord has pointed out. But again, it is a much more convincing and persuasive approach to statutory interpretation with respect. So in paragraph 19, the tribunal here sets out what we say are correct principles of statutory interpretation. So you can't start redefining words. The word bedroom is not defined, and it simply means any room which is capable of being used as a bedroom. Paragraph 20, you can't rewrite the test. This tribunal has clearly rewritten the test. And then, so they set out the approach they're adopting. They apply to B13 from paragraph 24. The material reasoning is paragraph 27. In our view, when read as a whole, Regulation B13 provides that in determining whether there is under-occupancy that triggers a reduction in housing benefit, one, the use or potential use of the relevant room or rooms can be any of the people listed in subparagraphs 5 and 6. Two, the impact of this is it has to be considered whether the relevant room or rooms will be used by any of the listed people. And three, designations or choices made by the Prime Minister who should occupy rooms as bedrooms or how rooms should be used is unlikely to have an impact on the application of the regulation. There's a slight qualification to regulation, to point 3, about there may be circumstances where the way in which a room has been used for some time might have some bearing as to whether it in fact truly is a bedroom. But it's not the case of just having 2 single children each using 1 bedroom somehow changes the overall criteria. So 27, we respectfully say, is entirely right as a way of approaching the legislation. And then 28 corroborates that, so it's again a social policy point. Tribunal says the underlying purpose of Regulation B13 would be undermined if this was not the case. 2, the purpose and the interpretation of the regulation shows that the test is focused on the availability of rooms that could be used as bedrooms by any of the listed people, and thus essentially the assessment of a property when vacant, rather than how it is actually being used from time to time. It seems to us that this is so because part of the underlying purpose must be to free up homes that are being under-occupied, so that they can be used by others with an entitlement to the number of bedrooms in the property, or to encourage the existing occupiers to make under-occupied bedrooms available to others. And they had discerned all of that for themselves, but the tribunal knew that.
Now, is that the first time that the concept of the property when vacant has occurred?
Yes, so Nelson uses this when vacant way of thinking about it.
It was an invention of the Nelson case.
Yes.
Yes.
Again, it's a useful way. We find it useful of analysing the problem. So we adopt it. It is property when vacant that is the right approach for the reasons given here. And the points about designation of rooms don't arise here. So that concerns a different question. Is it in fact truly a bedroom or not? So for all those reasons we say the tribunal has erred. I'll deal with any further points on discrimination, etc. in reply, unless I can assist.
Thank you. Anything else? Anything else?
I should have raised this when you were looking at IB. If we go back to IB at tab 9, and paragraph 23. And it's that first sentence. In this objective assessment, we do not consider that assistance can be drawn from paras 5 and 6 of Regulation B13 in concluding whether the room is properly classified as a bedroom. I confess to some difficulty with that, given the purpose is the construction of Regulation B13.
Yes, I understand the tribunal there to be saying that the size criteria themselves don't inform what a bedroom is,
Right.
other than the fact that it has to be capable of being used by categories within the size criteria. But apart from that, there's no, it's maybe the double bedroom point. There's no concept that a couple in the size criteria are entitled to a larger bedroom. So the word bedroom has to just mean anything that is a bedroom. And the fact that there are different types of categories within paragraph 5 has no other bearing on the question. That's how I understood the court to be interpreting it there. I don't know if that makes sense.
I'll think about it.
Isn't it set out slightly more eloquently, your point that a bedroom is a bedroom?
Yes. Bedroom is a bedroom, doesn't matter. You don't look at the couple, etc. It has to be a bedroom in the sense that...
No, it has to be a bedroom,
Yes.
but once it's a bedroom, it's a bedroom.
Yes.
That
that is my point.
Right. Thank you, Mr. Brown. Miss Meacher, has Mr. Brown left anything out?
He hasn't. He hasn't left much out. Perhaps there's just a couple of slight points I would like to elaborate on, if I may. If it will assist the court, obviously. If it isn't, then no doubt you'll indicate to me that you don't need to hear from me further. The main point I would like to stress is really how the case developed perhaps before the upper tribunal, and in that context the background, because when this matter came through from the first tier tribunal for the upper tier tribunal, the issue was, and as Mr. Brown has said during his submissions, the issue really was about this absurdity point and whether the property changed size depending on the actual household in occupation of the property. So there was this absurdity that it could be said that with Mrs. Hockley's family in occupation, it's a one-bedroom property because 2 of the bedrooms are not big enough for the 2 children to share. Whereas if another family was in occupation, which had 2 children of a different gender at the same age, then it would become a 3-bedroom property. And one of the points I sought to make in my skeleton argument is that whilst it would seem to be absurd in the suggestion put to Mr. Brown that there would be 3, if there were 3 single bedrooms, that couldn't be a 3-bedroom property, that would be absurd. It's equally absurd, in my submission, for a property to change size depending on the composition of the household that is in actual occupation of it. But where the upper tribunal in this situation went wrong, in my submission, is in actually raising the connection, or making their decision based on the connection issue that has been raised on behalf of Mrs. Hockley. That was not an issue that was raised by the first tier tribunal. It came first, if I may put it, before the upper tribunal.
But so what?
If I may come on, the reason for the so what is exactly the point that Mr. Brown has made, is that the statute doesn't bear an interpretation of there being a connection
I think
issue.
we have that point. Mr. Brown has made it, and we've certainly got it.
The further point, I appreciate you've got that point, but if I may just make this one further point, as a comparator, and that is that one of the additional elements of the policy that is set out in the evidence that the Secretary of State has provided is for those living in the social rented sector to be treated in the same way as those tenants within the private rented sector. Now, obviously, paragraph B or regulation B13 does not apply in the private rented sector, but there is an equivocal provision in regulation 13D. It has exactly the same criteria.
You mean equivalent rather than equivocal?
Equivalent, of course, my lord. With the same criteria, and how that works in practice, or how it has worked in practice before this regulation was introduced for the social rented sector, was where the local housing allowance is paid to a privately renting tenant. They are allowed a local housing allowance, which is a set figure for the particular area, which is determined by the number of rooms they are entitled to under the size criteria. So if a person like Mrs. Hockley was entitled to a 2-bedroom property, she would receive the local housing allowance equivalent to 2 bedrooms, and that would be a set amount. It wouldn't matter what property, in effect, she was living in, so long as it had at least 2 properties, that would be the only amount she would be entitled to. If she was, it would be a matter for Mrs. Hockley whether she would be living in a 3-bedroom, 4-bedroom property. If the rent was higher, it would be for her to make up the difference between what the local housing allowance she was entitled to and would be paid versus how much her rent was. And my submission is that should be seen as the context, if more was needed, beyond what Mr. Brown has said, for how one applies the size criteria in Regulation B13, in the sense that it is an objective assessment of what your criteria entitlement is. In a sense, it does not matter what property you are living in, it is that amount of those number of rooms that you are entitled to, and that will be the amount of benefit that you will be entitled to claim. It is then up to you, as the claimant, if I can put it that way, to determine whether you continue to live in a property where you aren't receiving sufficient cash benefit from the state to meet the rental income, or whether you make a choice to try and move to a smaller bedroom property, or whether you find another way, the mitigation ways, to meet the differential.
So what's actually going to happen if you and Mr. Brown are right? Miss Hockley will find that her housing benefit is reduced. She may or may not be able to make it up from other sources. If she does make it up from other sources, then she stays, does she? And if she doesn't, she fails to pay the correct rent, and what you put her on the street?
Well, my lord, if I can address that in 2 different ways. Firstly, between 2014 and 2017, the 14% reduction did apply to Mrs. Hockley because she hadn't made an application for discretionary housing.
Yes.
She was not in rent arrears. She had made an earlier DHP application before 2014, but that had been refused.
Yes.
And she has had one since 2017. But it's not simply a case of...
Just pause there. So she had made an earlier application.
She had.
It had been refused.
Indeed.
So she, whatever cost to herself, she got on with it.
My lady, yes.
Right. And then it was only paid because of these proceedings.
Well, my lady, when a new application was made, it was made on the basis that these proceedings were ongoing.
So in other words, there were a change in her circumstances as compared with when she made the first application, which was refused.
My lady, yes.
So some may say she deserves every credit for being able to work, because she does work. I know that her partner doesn't on the papers. So she worked in order to make up the shortfall.
My lady, yes. And that is one of the stated, as it were, the phrase that's used in the policy is choices, that is open to a household who are living in a property whereby they are subject to this reduction but they want to stay in a larger property. There are various mechanisms as to how to meet that difference. they can use income, they can use savings. Of course, there may be many tenants who don't have savings, that may not work. Lodgers is another example that has been identified. But of
Well,
course,
lodgers just isn't on.
for this particular claimant, of course, it isn't. But it is one of those other mechanisms that may be available to other claimants. But the other option, of course, is an application to move to a different property, to move to a 2-bedroom property where the second bedroom is of sufficient size for Mrs. Hockley's 2 children to share. So it wouldn't be a case, addressing my law's point, of that Mrs. Hockley would simply be thrown on the street. Any claimant who is in a position of being subject to the spare room subsidy and the reductions can make an application to move to a suitably sized room for their suitably sized property for their household. That can be by way of application, but there's also mutual exchange and various other mechanisms that can be used by a social sector tenant to move properties. And they are the same choices, if I may put it, that are before.
Well, is Nuneaton saying that they will rehouse Mrs. Hockley in a 2-bedroom apartment that has enough room for 2 young boys to sleep together?
I can't answer that because that isn't a proposition that has been put to Nuneaton as something Mrs. Hockley wants to achieve. She wants to stay in the property where she is.
But she could apply.
But she could apply.
We don't know what the result would be, but she could apply.
Indeed, she would certainly be able to apply, and she would be entitled to a property of the appropriate size for her family. So it isn't a stark situation of if she can't meet the difference, she therefore becomes homeless on the street. That's not the situation. It isn't the actual situation in this case, but that also isn't what would be the situation perhaps were it to be another claimant who couldn't meet the difference. If it were to be the case that as decreed by Parliament, their size they're entitled to as a property was different, they would be entitled to apply to move.
But the mechanism of the regulations by reducing the available, in inverted commas, rent, reducing the benefit, is clearly aimed at affecting behaviour. That is to not have people who are in properties which Parliament has considered is inappropriate for them to move to properties that Parliament considers appropriate. But there is a in some cases a choice where this shortfall, which is clearly a very significant one, could be made up in some other way, depending on the circumstances of the particular case.
My lord, yes. It's sort of one of 2 options. Either move to an alternative property that Parliament says is the correct size, which means your rent will be less in the social sector. The rent will be less because it is for a smaller size property. The housing benefit you will be entitled to will be the full amount, but of course it will be less because your rent is less. So there comes the saving to the state, if I can put it that way, and there is no additional expense to the claimant in having to pay the shortfall, although there may be obviously an immediate temporary one-off expense of the cost of moving. One can't overlook that. But equally, a claimant isn't, as it were, forced into that situation. They can make a choice to stay in the accommodation that Parliament says isn't the right size, but that choice comes with its own cost, which is you must meet the difference between what the state pays, but then the state benefits because the state has a reduction in the housing benefit it pays. So that is the intention in my submission of this statute has been set out by Mr. Brown. Sorry, forgive me, I've lost my train of thought. I think the other factor that Nuneaton would like to highlight is one that, my lord, you raised earlier in terms of having inspectors needing to go and assess individual properties, because the situation as currently is, when the local authority has to assess a particular claimant under these provisions, there is an indication, a strong indication as to what the size of the property is by the tenancy agreement.
Do we have the tenancy agreement?
My Lord, I don't think it's in any of the bundles you've been provided. I do actually have it at court, should the court be assisted by seeing it.
Does it say that it is a 3-bedroom property?
It does. It says there's no dispute about that. It says it's a 3-bedroom property and suitable for 4 people.
Yeah.
So when assessing a claimant in this situation, the local authority will obviously determine the number of rooms, and that is ordinarily the starting point for that is going to be the size of, what the tenancy agreement says. We of course you have heard about the case of IB and Nelson, where there were other factors that may change what should be considered the number of bedrooms. The local authority then considers the composition of the household, so the numbers, what their ages are, what their genders are, and it has an objective sum of what the size criteria is that applies to that family. In doing so, it can then decide whether the spare room subsidy applies, so whether a reduction should apply or whether it should not. The consequence of the upper tribunal decision, if it is correct, and if that's what is found to be the case, will change quite considerably for the local authority what it needs to do. Not in every case, but certainly in a number of cases, such as Mrs. Hockley's case, there may well be a dispute as to actually whether the number of rooms in the property actually is appropriate for the particular categories in paragraph 5, and thereby we're in a situation where the local authority will need to go to those properties to assess and make a subjective judgment as to whether that property, that room, is appropriate for that particular category. And that will apply for each room or each category, as it were, within paragraph 5, and each property where that is in dispute. That is a considerable great deal more work for the local authority, but of course goes without saying a considerably greater area for dispute between the local authority and a household as to whether it is the appropriate size property or not. The type of difficulties one can get into in my submission are amply illustrated by the first tier's judgment in this particular, the statement of reasons in this particular case, where detail was assessed as to whether bunk beds could fit in, whether there would be enough storage for 2 people, whether there would be wardrobes for 2 people. One amplifies that out to all the properties, as it were, where at least a category requires 2 people to share. So each couple, is it big enough for a couple? Is it big enough for 2 of the same gender? But the same also applies to the other categories where they're entitled to a single room. Is it a big enough bedroom for that particular person? Mr. Brown obviously gave an example earlier of the person who may be very tall. A single room may not be sufficient for them. We then get into the rounds that this just goes from each room to each category, of a subjective assessment having to be carried out by a local authority officer as to whether it is an appropriate size. And if not an appropriate size, take the approach that the upper tribunal has suggested, stated in its decision, which is that in fact what happens in that situation is your size category changes, and therefore you may well be entitled to a larger a room that is larger. But what happens if there is no other category for you to go down to? Because an adult, someone who is over 16, is entitled to 1 bedroom. There's no other category. Perhaps they go up to, as Mr. Brown said, the couples category, so they have a double bedroom. But where do you stop? Does that mean everyone, if you take it to its logical extreme, almost everyone becomes entitled to a double bedroom? So all rooms have to have double bedrooms?
I think we're alive to the points that both you and Mr. Brown have made. Yes, thank you.
Unless you need me to assist you further.
Thank you. Yes, Mr. Joyce.
My lords, my lady, the Secretary of State describes this legislation as affecting the removal of the spare room subsidy. The upper tribunal was right to conclude that the removal of the spare room subsidy does not require a deduction to be made from Mrs. Hockley's housing benefit in circumstances where there is no spare room. There are 4 people in the Hockley family: mum, dad, 2 children. It's a working family on a low income because of disability, and they live in a house which fits 4 people. They wouldn't be allowed to have anybody else come and live in their house. The first tier tribunal found that no family with their composition, mum, dad, 2 sons, would have a spare bedroom. So it's important at the outset to be clear that I accept entirely the proposition put by Lord Justice Hickinbottom, who I know is very experienced in social security law and practice, that the use of proxies is an inevitable part of social security legislation. And that there are 2 important respects in which plainly this legislation is using an abstraction from the particular circumstances of a person's case for simplicity. So, for example, we wholly accept that the application of this legislation requires a property to be considered in its vacant state. So it has nothing to do with the individual usages of the family. And we wholly accept that the upper tribunal was right to say that the reference to the different categories of users of a property, of occupants of a property, forgive me, are depersonalised. So we're not interested, in response to my learned friend Mr. Brown's example, in whether a member of the Hockley family is particularly big. The important thing is that nobody with their family composition would have a spare room. One other point that's worth perhaps making at the outset when we come to construe the legislation that's the subject of this appeal is that this is legislation to be understood and applied by laymen. The local authorities who are charged with making housing benefit decisions aren't professional lawyers. The claimants who claim housing benefit, and in fact, to her very great credit, Mrs. Hockley took this case successfully through the first tier tribunal, all by herself, because there's no legal aid for benefits adjudication even at that stage. The people who have to understand and apply how this legislation works are not lawyers. In my submission, the 3-judge panel of the upper tribunal that was constituted to hear this appeal, recognising the importance of it, reached an interpretation that fits with the textual meaning, first, the mischief being tackled by the policy of the legislation, second, and thirdly, the requirement of any public authority to avoid unjustified discrimination. I propose to make my submissions in that order. Now, on the text of Regulation B13, it's important that I'm absolutely clear about what we say it is that the upper tribunal decided. As the Secretary of State said, it's probably fair to characterise all social security legislation as a rough regime with rough proxies. It's not perfectly adapted to every nuance in an individual circumstances. It would be a straw man to suggest otherwise. The question is how far this legislation is nuanced to the circumstances of particular individuals. And we say that it makes more accommodation for the real circumstances of people like Mrs. Hockley than the Secretary of State says it does. But the Secretary of State accepts that there's some nuance in it. It looks at, well, how many bedrooms, who is in the family. It's not a completely flat, you're a tenant, you can have a fixed amount of money that's uninterested in your circumstances, but at the same time, I've already accepted that the depersonalised character of the groups and the approach to look at the property vacant are proxies. The upper tribunal did not decide that Mrs. Hockley's house is a one-bedroom house. That's important because the Secretary of State, in her skeleton argument, there are two skeleton arguments in the Secretary of State, I mean the main one, did assert that, and at paragraphs 10 to 13 of her skeleton, took the court through a series of scenarios at which it said revealed the absurdity of the upper tribunal's decision. So you'll find, I don't invite you to turn it up now, but you'll find it at 15 to 16 of the core bundle. The upper tribunal reached the perfectly understandable conclusion that the Hockleys have a 3-bedroom house up, which, as my lord pointed out, accords with its description in the tenancy agreement. There's one double room and then there's 2 tiny box rooms. I think, well, I'm not sure whether it's in the record or maybe we'll need further elaboration, that the 2 box rooms are one historic room divided by a stud wall. Certainly,
that was the finding of the first tribunal. Yes.
Certainly, everybody accepts that they are very small. If we're successful in defeating this bill, there'll be further litigation about whether they genuinely are incapable of accommodating more than 1 child per room. The upper tribunal was not deciding what is a bedroom. And when I turn to Nelson and IB, I'll say that the reason why those cases don't cast doubt upon the decision of the upper tribunal here is that those are cases about what a bedroom is. What the upper tribunal decided here is, can a family's bedroom entitlement be assessed by reference to the property for which housing benefit is claimed, or must it float free of the property?
I'm sorry, can you give at least me that again?
Yes. Can a family's bedroom entitlement be assessed by reference to the property for which housing benefit is claimed? Or does it float entirely free of the property? Because the Secretary of State says the Hockley family will always, at all times, have a bedroom entitlement of 2.
Was as it were currently constituted?
Yes. Yeah. Forgive me. Yes, it's common ground that in about a year and a half, happily, they'll escape the jaws of this problem. We say that having regard to the legislation as a whole, just looking for my authorities bundle. Oh, thank you. The tribunal was right to conclude that it is appropriate to have regard to the property in its vacant state for which housing benefit is claimed. I'd like to take you now to the legislation, and first, briefly, I'd invite you to turn, it's at tab 1 in the authorities bundle, I invite you to turn to Regulation 70. It's the very last page of tab 1.
Maximum housing benefit.
Maximum housing benefit. So, at a very elementary level, when we analyse what housing benefit is, I don't think we have we don't have the primary statute, which I think is the Social Security Contributions and Benefits Act 1992, but I don't think much turns on the primary provision establishing housing benefit. But it's a benefit which is intended to support people on low incomes to live in their houses. It doesn't provide an amount of money that is free floating from the circumstances of the property, because it is his eligible rent which limits his appropriate maximum housing benefit. So it's not a system that's so rough and ready that it will pay amounts that exceed the sums that a person is liable to pay. Which is a very good reason that what a person needs to pay to be able to enjoy their stable home life without dispossession is their rent, not more, not less. And the social security system has other benefits that provide for other subsistence needs. Now, the maximum rent in the social sector is then further limited by Regulation B13, and I invite you to turn back 3 pages to it. I think we're all agreed that the critical subsection is 5. And in my submission, the critical word, although I'll submit and hope to make good my submission that it's important to read this legislation in context and as a whole. The claimant's entitled to 1 bedroom for each of the following categories of person whom the relevant authority is satisfied occupies the claimant's dwelling as their home. Again, there's a focus on the particular dwelling. Each person shall come within the first category only, which is applicable. Then there are a series of depersonalised situations. The just as an aside, when you come to write your judgment, I think the correct analysis is that the upper tribunal cited the legislation as it was in force on the date of the local authority's decision. That the Secretary of State's annotations to this helpfully show that the BA substitution was from the 4th of December 2013, and then the ZA-ZB was from the 1st of April 2017, they're side noted. So in fact, at the date of the upper tribunal's judgment, this was the correct and full subpara 5, but the passage as cited by the upper tribunal is what was in force on the date of the decision, which of course was what it was bound to apply. But nothing really turns on that. Is the category two children of the same sex applicable? That's the key question. Now, if you just ask that divorced of context, then you're very likely to say, well, yes, those are two children of the same sex, the Hockley boys. But what is it applicable for? It's for the purposes of saying that the claimant is entitled to one bedroom for them.
I want to get this because this is, I think, crucial. So you accept that on the face of it, that these children fall in C.
What I say is that if you simply showed me a list of
A to E.
A to E
They would fall into C.
and asked me which is applicable, they would fall into it.
No, sorry, I understand that.
Yes.
And then you've gone back, as I understand it, to the word applicable.
Yes.
Shall come within the first category only, which is applicable.
Yes.
And then you said that the question then is, what is it applicable for? And then you answered that question.
Can Parliament have intended that that category would be applicable to the Hockley boys? Well, it generates the result that Mrs. Hockley is entitled to one bedroom for them, but on the Secretary of State's analysis, that entitlement includes a bedroom in which it's impossible to fit them. That's the part of the analysis which, particularly to a layman, is very difficult to understand. So I'm entitled to a bedroom, but well, what do I do with that entitlement?
I'm sorry, but Mr. Brown's submission was this, that subparagraph 5 does not entitle you to a bedroom. It simply doesn't. Subparagraph 5 concerns entitlement to benefit, and subparagraph 5 assists with the calculation of the benefit, but it doesn't entitle you to a bedroom.
Well, it doesn't. I suppose that to that I'd give the perhaps unhelpful answer. Well, it depends what you mean by entitled. I mean, Mr. Brown is in a difficult position in saying subparagraph 5 doesn't entitle you to a bedroom, because it begins with the words the claimant is entitled to one bedroom.
But for what purpose?
Yes.
Perhaps that's a better question.
Well, and that's why I'm going to come on to the policy issues. In my submission, it is actually quite important in this case to identify what it is that Parliament was trying to achieve, because whether you give no force at all to those beginning words, the claimant is entitled to one bedroom for, or whether you give them quite a lot of force, will turn on your analysis of what it was that Parliament was trying to achieve. But it certainly, to come back to the point that I may have already made sufficiently, it will surprise the layman to learn that the words of the claimant is entitled to one bedroom. To use your lordship, don't mean that you're entitled to one bedroom for them. The upper tribunal commented on the fact that it would have been very straightforward for the legislature to use a different construction, which, if it didn't mean to import reference to the property, would have been very straightforward to achieve the sort of construction that my learned friend is contending for. The word bedroom is, on my learned friend's construction, really unhelpful, because immediately one thinks of a bedroom, and in fact a bedroom at the property, and the word for is unhelpful because you think of the relationship between the bedroom and the depersonalised categories. It is a room that is licensed to accommodate one person and can only accommodate one person in any meaningful sense, a room for two people. Instead, the Secretary of State could have made paragraph 5 just a point scoring exercise. Claimant is awarded 1 point. That would have been, if my learned friend is right on the parliamentary intention, a much more explicable approach to the analysis which he says follows, which doesn't actually, the word bedroom there, on my learned friend's analysis, plays no role at all. It's a pure cipher. The two cases which came before.
Mr. Austin, my apologies for taking you back, but
No.
Quite early on in your submissions, in respect of B13,
Yes.
you told us that the critical subsection was 5.
Yes.
And you said there was a critical word.
Applicable.
Thank you.
And so, can you just divorce, if you can separate out those sub-paragraphs A to E, as I said in answer to my Lord Hickinbottom, if you showed any of us in this courtroom a list of those and said which is applicable to the Hockley boys, well, the answer is it's clear. But the upper tribunal took the approach that hardly an unconventional approach, that in construing legislation it's necessary to read the legislation as a whole rather than to take out of context just one sub-part of a sub-paragraph. I'd like to address you briefly on Nelson and IB. I've said already, by way of trailer, that these are cases which decide what's a bedroom, not what is a household's entitlement. And I want to make that good by brief reference to those cases. So I'll take you to Nelson first, tab 5, and paragraph 2 of the decision. I'm afraid it's an unpaginated judgment. There were 2 single adults in this house. They were brothers. That's at para 2. everybody accepted there were 2 bedrooms. There was a 3rd bedroom about which there was argument. It was about 8 feet by 8 feet. And then at para 37, so para 37 gives the 8 by 8 reference. Para 38 explains that it could and had been used as a bedroom for a child, and then in fact, going further at 64, sub-para 5, so it's over the page from the beginning of 64, there's a finding that in fact it could be used by a child or indeed an adult on a full or part-time basis. So you've got 3 rooms that are bedrooms, single adult 1 in room 1, single adult 2 in room 2, and then they say of room 3, well, a variety of things. One of them is, well, you shouldn't call that a bedroom at all because that room doesn't comply with legislation about space standards. And so in other contexts it might be classed as a risk to human health, or there's a variety of arguments about it not meeting minimum legislative standards from other contexts. Those are rejected.
But the first chair tribunal in that case had held, am I right, that the bedroom was suitable for a child but not suitable for an adult. And what the upper tribunal were concerned to say was that still a bedroom if it can be used by a child.
Yes. I'm saying yes to the second part of my Lord's comments. I'm not saying no or yes to the first part because I don't immediately know. I have to just look.
Well, that's why they reversed the first chair tribunal.
Well, in my submission, their principal concerns were about whether legislation would, in other areas, would mean that you couldn't term something a bedroom, and also whether a tenant's personal use of a room could affect how that room was classed. And my Lord is no doubt right about the further point. All of those are about what's a bedroom. There's no issue about the room entitlement of the household members. It's 2. There were 2 rooms.
You say it's a classification issue.
Yes.
Yes.
So they've got a 3-bed house. They've got an entitlement to 2 bedrooms, and they don't mount any argument that could be conceived of as being an argument for extra bedrooms. Then IB, in my submission, is essentially the same. So we're tab 9. What you have here is one tenant on her own, a woman with quite significant disability and consequential care needs. And she has overnight carers, so paragraph 3 provides a useful summary there. And the inner house says This is 709 of the page 709 of the judgment. Paragraph 3. A tenant of a property comprising 5 main rooms plus kitchen and bathroom. She lives with SO and DMO who care for her. Again, paragraph 5 shows us there was no doubt about there being 3 bedrooms in this property. The dispute about whether there were 4. What she said was this 4th room isn't used as a bedroom. So, para 21 at 715 in finessing Nelson, to the extent, however, I'm at the bottom of page 715, about halfway through, oh no, 3/4 of the way through para 21. To the extent, however, that the upper tribunal entertained the possibility that the designation or choices made by family members as to who should occupy bedrooms or how rooms should be used had any relevance, we do not agree. So again, it's about bedrooms rather than entitlement, and it's also depersonalised. Now, my learned friend acting for the local authority said referred at one stage to the Hockley family as representing to the local authority, well, we use the property in this way. Now, what's vital to understand about our case is that there is nothing about, we're relying on nothing about the personal choices made by the Hockley family. We're wholly content to say that the assessment must be by reference to the depersonalised category of mum, dad, 2 sons who haven't turned 16 yet. So, the case that this court is presented with today does not turn on choices made by individuals, and it does not turn on the question of how many bedrooms Wisteria Way has. It's 3. We all agree it's 3. I want to briefly touch on Carmichael, even though I'll come back to it again when I address discrimination, because Carmichael is the 3rd case about which it's said, well, that that's a higher authority which is against me. I don't accept that. Yes.
Just on what you said last, that you weren't relying on any choices that the family had made. I understand that.
Yes.
And you accept that there are 3 bedrooms. So it's a 3-bedroomed house.
Yes.
Just looking at, and you may be coming on to this, and if you are, deal with it in your own order. But looking at subparagraph 5. The claimant is entitled to 1 bedroom for each of the following categories of person, etc. And so going down those, how do you get to 3?
Yes. You've
got a couple. We've got one of those. We've got mum and dad.
Yes.
And then you go down a person who is not a child. No. 2 children of the same sex. Yes.
Yeah. Well, that's what the Secretary of State says.
No, I understand that. But what do you say?
I say it's not applicable because it has to be the concept of what's applicable has to be understood by reference to the beginning words of paragraph 5 and indeed the general policy of the housing benefit regulations, and also by reference to the submissions that I'll make in due course about what aim Parliament was, what other evidence there is about what Parliament was trying to achieve.
Just on the words, how do you get there? Claimants entitled to 1 bedroom for each of these categories. We go down the categories. We've got a couple, and going down, just looking for the 2 children. We've got 2 children of the same sex. Those are the first 2 categories you hit. That's 2 bedrooms. How do you get to 3 bedrooms?
For mum and dad, you get to A, that's applicable.
Yes.
For the Hockley boys, you go down. I say, this is indeed at the centre of the argument between the parties, I say, and the upper tribunal says, C isn't applicable because that generates a result where you have to conclude the claimant is entitled to 1 bedroom for that category, and Parliament can't amend that. So it must have had a wider concept of applicability.
What we're talking about there is applicable. Applicable refers back, as a matter of English, to category. Within the first category, which is applicable. Yes? So
Well, applicable doesn't... It's an applicable category, but it can't be referring to category. It's referring to...
What has to be applicable is the category, as a matter of English.
Well,
and these 2 boys fall within category C. What applicable does not refer to is the bedroom. It applies to the category, not the bedroom. But you're suggesting, really, it seems to me that it applies to the bedroom. The bedroom in some way is not appropriate for these. One of these bedrooms is not applicable in some way, appropriate in some way.
Yes.
For these 2 boys, well, that's right, but that's not what the words say.
well, I mean, if that is your final conclusion, then
I'm just looking at the grammar. I'm just looking at the grammar. Applicable, as I say, doesn't refer to the property. It refers to the category.
But you say, as I understand, that it's not applicable to the category of 2 children of the same sex because they can't fit in.
yes,
That's your argument.
yes.
Yes.
No, but I'm sorry, but that's focusing applicability on the bedroom. I understand that the bedroom isn't appropriate, or in that sense applicable, because you can't get these 2 boys into one of these bedrooms. I understand that. But applicable there doesn't refer to the bedroom. It refers to the category.
Well, that wasn't the view of the upper tribunal, and I suppose it's necessary in part to go on and look at what the evidence shows about what Parliament appears to have been trying to achieve. Because if one takes that approach, that there's an answer of pure grammar that requires you to separate out from subparagraph 5 the parentheses and then the list, then I think the subject to what I might say about the Human Rights Act point, the Secretary of State would, and that's the Secretary of State's argument. But in my submission, it's not clear that the applicability is a reference merely to the categories. So in IB...
No,
oh,
just take
forgive
that.
me, yes.
You say it's not clear that applicability is referenced merely to categories.
Yes.
So, taking my Lord Justice Longmore's point, are you saying it also encompasses the type I'm just trying to understand exactly what it is you're saying.
That the legislature cannot have intended that a person would be entitled to one bedroom for two children of the same sex, in which it was impossible to accommodate them, and that therefore, reading sub-para 5 as a whole, the applicability requires one to have regard to there being a room that can accommodate that category. That's the reasoning of the. I think I'm fairly representing the reasoning of the tribunal.
Yes. Just looking at the way it's printed, if one is actually focusing on precisely what the words mean, there is actually a misprint, isn't there, in what we've been provided, in that there must be a closing of the bracket, which begins, and each person shall come within the first category, presumably after the word applicable and before the hyphen.
Yes, I think that must be right.
Yeah.
I'll just look at my. I think I have a copy of the Westlaw text, and I'll see whether it's presented differently.
And certainly, I don't know where the upper tribunal got it from. They have inserted, if insert is the word, a bracket there.
If it assists, my lord, my Westlaw copy does indeed have a closing bracket between applicable and the
So
hyphen.
what is it that we've been provided with? Just the department's own working copy?
I think I'd have to leave my learned friend to.
It's an encyclopedia. This is the encyclopedia of social security, I think.
Yes.
It's
We'll see that at the bottom.
yes.
We produced this, and it must just come from, well, it came from the library.
This is not an official. It's not an official version. It's not a.
No, it's a secondary.
It's a secondary source. It's from the encyclopedia of social security.
I apologise. I dated it earlier as well, but I was absolutely right. That bracket must be missing. We can obviously supply an authentic.
Right.
But my focus on applicable was only because you said it was the most important word in the provision.
Well, it is, but it's important not to take it on its own.
You've got to read the whole thing as a whole.
Yes, exactly. But what I mean is that the court is ultimately answering the question of what applicable means. But it must do it, I submit, by reference to the whole section.
So those are your arguments on the language.
Yes.
Are you going to make any submissions about the mischief?
I am, and I'll do that after lunch if the court is so minded. What I'm going, in the minute remaining to me before 1 o'clock, what I'm going to submit is that the approach taken by the Secretary of State and the local authority is to say that the policy, or one of the policies, was to encourage people to move to more suitable property. I'm going to say that is too vague. More suitable property could mean any number of things. Property will be more.
You're going to make this submission after lunch. Why don't we let you do it after lunch?
Thank you.
Very well. 2 o'clock.